Minister, I welcome the opportunity to speak in this debate this morning. There's clear evidence for the need to reform and change the in-camera rule. In practice, the rule restricts evidence, protects perpetrators and not victims. It has created a culture of secrecy that shields abuse and acts effectively as a gagging order. While in theory it protects privacy, but in practice it often prevents public accountability and hinders supports for vulnerable people through its misapplication. In your amendment, Minister, you mention a detailed examination being undertaken by officials and findings and recommendations from the report on the operation of the in-camera rule, including a review of the Transparency Project and the use of transparency orders in England and Wales. And the question I have, Minister, is when are you going to take action on foot of recommendations for reform, including transparency orders? The independent research report was published almost a year ago, and we need a commitment to transparency as a priority beyond acknowledging it as something you value. On the specific point about transparency orders, a PQ reply that I received sidesteps the question. It says officials are examining developments in England and Wales, and we need an indication that these are being actively considered for Ireland. There's a clear gap, and we need a structured transparency regime like transparency orders. And there is a notable emphasis throughout on privacy as opposed to transparency, which feels like the groundwork is being laid to push back against the deeper reforms that are necessary. Minister, it's become internationally accepted that the blanket enforcement of the in-camera rule-style procedures in family law matters is unacceptable. We need to at least see a pilot on rule change. Minister, I've had women come to my clinic and tell me that the in-camera rule is simply put a cloak of invisibility for the failings of family court. I've been contacted by women who've been threatened by judges with the DOCA Centre and having their children removed from them for non-compliance of contact orders. But when they try and challenge and explain this, they are shot down. They are told that often that it's not you he has a problem with, or it's you he has a problem with and not the children. And these comments are stated in cases where the father is accused and sometimes convicted of domestic and sexual violence against the mother. With the in-camera rule in place, we have no accountability for the manner in which some judges and barristers treat women in court. I would also like to support an amendment that's going to be moved by Deputy Gibney. We need on the bench access to relevant case law. There's a good example there in Australia with the National Domestic and Violence Bench Book. We need to introduce that.
Thank you for watching. Please like and share.